My lord, I am extremely sorry for yesterday's news. I can take you.
Yesterday is past. Now we are present.
My lord, today 4 cases have been listed. Almost all the cases are similar in nature. But even then, my lord, item 1 and 45. 45 in the custody and 1. These 2 I will do. Lordship may kindly adjourn item 41 and 42.
Okay, both sides are represented. Just after 2 weeks, as prayed for by the land counsel for the petitioner. 41, 42.
Yes.
Okay.
But 1 and 45 I will do.
Okay.
On 45, my lord, he is in custody. Perhaps it will be taken first item. I think so.
45. Not 45 after motions only. Oh, this is IA.
IA for bail, my
Okay,
lord.
I will take it up early. Yes.
May I please, Your Lordship? My lord, I have prayer for listing of a case, my lord.
Listing, give
was-
to the court master.
My lord, please.
Number 4.
Prayers for listing, give it to the court master.
I beg to mention item number 39. I have some personal problem today. Only for the day.
Item
Item 39, my lord.
13.
Only for the day, my lord.
It goes after a week.
My lord.
39. Okay. 39 after a week. Yes.
May I appeal? I beg to mention item number 2, my lord. In this case, my lord, Ahmed will appear for the day, my lord. Next.
Item 2 after a week.
Your Lordship, permission in item number 43 may be upgraded, my Lordship. I have come from outside, my Lord. It was listed for today, 43.
43.
Yes, my Lord.
Okay, before rising, we'll take it up.
Oblige me.
May I
You
please
inform the other side.
Yes, my Lord. I have already informed.
Yes.
May I please, Your Lordship? I beg to mention upgradation of item number 44, Lordship, as item 1. I have taken consent of the other side as item 1, Lordship.
Okay. Okay, this is habeas corpus.
Yes, Lordship.
Okay. This is the case where the AG is also appearing.
Yes, I have taken his consent.
Okay.
Did you like?
I beg to mention, my lord, item 22.
Just a moment. It will be after the motions. After we complete the motions. After motion.
But I beg to mention item 22, accommodated for the day, my lord.
22.
22, my lord.
It's 2017 matter.
But for the day, my lord. Say admission
Matter is
matter.
very difficult.
Lord, I need to stand up for long. I have some back problem, my lord. My back is not supporting me. For the day, my lord.
It was more than 5 years matter.
Any day after today, my lord.
Okay, after a week. 22.
I'm grateful, my lord.
May I
Yes.
take Lordship? Lordship, in item number 6, Lordship, there's a typographical error, Lordship. I may be allowed to correct it. Oblige, Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 4, Your Lordship. Your Lordship, due to the arguing counsel earlier appeared earlier, Your Lordship may not take this matter, Your Lordship.
Hmm?
Due to the arguing counsel appeared earlier, Your Lordship may not take this matter, Your Lordship. In this matter, Ms. H. Petala appeared, Your Lordship.
Item number?
4.
You say I should not take it up.
Yes, sir.
Just see. I don't know. You see, in view of order dated 24/7/2024, I'll list the matter before any other bench without one of us. Present K.R. Surana ji.
Hello. May I please, Lordship? Lordship, I beg to mention item number 27, Lordship. So I'm praying for the adjournment of this matter, Lordship. Next week, any date, Lordship.
27. Okay, after a week.
Lordship.
Lordship, I beg to mention item number 29, Lordship. Lordship, kindly pass over the matter for that, Lordship.
29, same order after a week.
Highly request. May I
Ju-
please,
Just a moment. This item 29 will not adjourn. This is listed by orders. You made a mention and it was listed.
Lordship, my senior is out of it.
We don't know why you did make a mention. You make a mockery of the system. You make a mention, then get it listed, then you take an adjournment. No, it will not be adjourned. 29 will not be adjourned.
May I please, your Lordship, I beg to mention item number 5 for adjournment.
5. Okay, next week.
Highly.
Please, Your Lordship, with respect to item 38, it's for upgradation. It's an admission matter. The person is in detention.
38. We'll try because there's 2 habeas corpus matters only after that. Not
Much
before.
obliged.
38.
May I please, your Lordship. Item 37, my lord. The petitioner is in detention came by way of ex-parte order, my lord. So I may be, my lord, matter may be taken at 2 p.m.
We're not saying about 2 because there are 2 habeas corpus matters only after that.
37. Obliged.
May please, Your Lordship, I beg to mention item number 16. This matter may adjourn for the day, Lordship.
16. Okay, after a week. Yes.
Obliged.
Upgraded item 45 for orders.
May I please, Your Lordships, my lord. We have collected 2 photos, Lordships may kindly look to this. And I am behind the bar, my lord, since last 4 months, 6 days.
Yes, you have the status.
Lordship, yes, Lordship. He was supposed to do gallbladder operation, Lordship. So, Lordship, he has to now, he will be shifted to GMCH, Lordship. That instruction I have, Lordship.
Then we grant him bail if that is the
Yes,
condition.
Lordship.
Heard Mr. M.U. Mahmood, learned counsel for the applicant. You are appearing as CC? Okay. Also had Mr. P.K. Mehdi, learned CEC appearing for respondent number 1, Miss P. Barwa, learned standing counsel for respondent number 2, Mr. G. Sharma, learned standing counsel for the active matters representing respondent number 3, 4, 6, and 7, as well as Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 5. Next, in view of order today's order dated 17/9/2024, the issuance of notice on respondent number 8 is exempted. Next, by running this interlocutory application, the applicant, you were arrested when? When were you arrested?
On 22/7/24.
The applicant, who is the proceedee before the Learned Foreigners Tribunal number 1, Magalday, Darang, in connection with FT case number 1171 of 2012, was taken into custody pursuant to opinion dated 28/12/2022, was taken into custody on 22/7/2024 pursuant to opinion dated 28/12/2022, and is currently lodged in the transit camp, Matia, Gwalpara. Next paragraph. It is projected in this application that the applicant is not in good health, and he was referred to Gwalpara Civil Hospital for treatment, where he was treated for last 7 days, and then he is referred to GMCH, where he was kept for 5 days, and he is advised to undergo some surgery. Full stop. Next paragraph. By order dated 25/11/2024, the learned standing counsel for the active matters was requested to obtain the status of health of the applicant, including the current health status, as well as information as to the reason for the applicant's admission in the civil hospital Gwalpara on 19/9/2024. Next paragraph. Accordingly, the learned standing counsel for the FT matters has submitted that he is instructed to inform the court that the applicant is suffering from gallbladder ailment and is advised to undergo surgery. Next one. In that view of the matter, the court is inclined to provide that the family members of the applicant shall furnish a bail bond of rupees 5,000 with one surety of like amount on behalf of the applicant, namely Mohammed Maqsed Ali, alias Maqsed Ali, alias Musket Ali, three alias, huh? To the satisfaction of the said authority. Full stop. Accordingly, the bill to the Supreme Court Police Parang at Magalday. Next, on the production of a certified copy of this order along with the bail bond, submission of bail bond, etc. Within 3 days, the officer in charge, the Supreme Court Police within bracket border, Parang, shall do the needful for taking the applicant into custody, his custody, and he shall capture the iris of the eyes of the petitioner as well as fingerprints. Give other conditions. And thereafter, he shall be released on bail. Next para. As a condition of bail, it is provided that the applicant above named shall not leave the jurisdiction of Supreme Court Police Border Gwalpara without prior written information. Next para. Accordingly, this interlocutory application stands allowed and disposed of on conditions as indicated above.
But instead of Gwalpara, it will be Dorong perhaps. Instead of Gwalpara, it will be Dorong perhaps. He hails from Dorong.
No, you have made only Supreme Court Police Darang as party.
Yes.
He's respondent number 6.
But your lordship has said the Gwalpara, that's right.
Or maybe mistake, it's the Darang. It is Darang, Mangalday. Okay,
Master.
okay.
Upgrade item 47, supplementary list.
May I please? So the inspection was called for, my lord.
My lord, I have asked to concerned official lordship. They said that lordship petitioner never appeared before the concerned SP lordship, and during that period lordship, no such incident has been taken, in lordship happened lordship.
Mother died.
No, lordship. No such incident has been happened. My lord SP joined in September 2023 lordship. Till then lordship, no such incident has been happened lordship. Happening lordship.
Incident means he's alleging that the mother of the superintendent died.
No,
No, it did not happen.
SP no Solpur can again.
Both sides are represented.
SP
Pursuant to order dated 28/10/2024 and 27/11/2024. Mr. G. Sharma, Bennett, standing counsel for the FT matters, has submitted that he has received telephonic instructions to the effect that the Superintendent of Police, the present incumbent to the post of Superintendent of Police with the bracket border, bracket was Baksa, has joined in the month of November 2023.
September 23.
Or September 2023.
Oh.
And it is denied that that on or about 4/12/2023, the mother of the officer who is posted as Superintendent of Police within bracket border with Baksa, Mushalpur, had expired. Accordingly, it is submitted that the applicant did not appear before the said authority, showing his willingness to submit the bail bond. Accordingly, the matter stands adjourned to enable the Land Council for the petitioner to obtain instructions. At least after a week on a date to be fixed by the office. We are giving you time to instruction. We are not dismissing it. Find out.
Right. Instruction.
Oblige me.
Item 1 for motion.
We are admitting him for hearing, January.
Yes, Lord.
You are already on bail.
My lord.
uh, All sides are represented. The records of the tribunal is received. As the matter requires some examination, the court is inclined to issue rule returnable forfeit without requiring the petitioner to take fresh steps. This is the matter for hearing. The month of January 2025.
My lord.
Item 3 for motion.
The report was called for, my lord. Lordship, case was disposed of, Lordship. One page was missing, Lordship. That's why. So, after first page and last page was taken by the Lordship. Lordship, at this page, let the records come, Lordship.
Samir Paul.
Yes, Lordship. Huh? Oh.
So it is disposed of.
Yes, Lordship.
So you'll have to call for this record also.
Yes, Lord. Oh.
All sides are represented. Mr. G. Sharma, standing counsel for the FT matters, has produced a photocopy, a scanned copy of the opinion dated 29/12/2020, passed by the learned member, Foreigners Tribunal, DIFU, in FT case number 12 of 2018, arising out of police reference case number 1 of 2018, in the matter of the petitioner Samir SAMIR, Samir Pal PAL, by which make an ex-parte opinion. Ex-parte opinion by which he was declared to be a foreigner of post 25/3/1971 stream. You have a certified copy of the order with you?
No,
Opinion?
I have given Xerox. No.
Just show us your copy.
I have given a Xerox copy.
Just show it.
And they have taken the certificate to be lordship. That application also sent lordship.
Can you, give the copy of your writ petition, just. But Mr. Sinha,
Yes, madam.
you are comparing us to you have recently seen what has happened
Yes,
in
madam.
Delhi.
Yes, madam.
It come to your notice. We'll have to do the same here. Because of the fact that you see, you see your
Yes, ma'am.
order, copy of the opinion.
Yes, madam.
Yes, page number 1,
1 of 3 and
1 of 3, and second is 2 of 3. So where is page number 2?
Yes.
Wait a minute. That time I have overlooked it, but I have just seen madam.
No, but if you don't see that, it is dereliction of duty. Number 1, it is lack of assistance to court, and then you are misleading the court.
No, madam, that is not.
Then why we should not direct that an FIR be lodged?
No, madam, that is not. And then copy that is given to me is there, madam.
No, we know that, but you see, you are an officer of the court. We rely on you. It is because of your presentation that we had to make an inquiry, and then it has come out that the second page was not photocopied by you and not produced.
Yes, ma'am.
So why we should not take a serious note of that and proceed against you?
At that time, then I overlooked my.
Certified copy, you see, that means you are certifying a copy to be true without even looking at the original. The certified copy is not with you. You don't file the certified copy, and now we see that the second page is not done. And so it has and this writ petition of 21 for 3 years. This matter has been lingering. So tell us why we should not proceed against you.
Please, I'm sorry, my lord, I have not overlooked this my particular matter.
No, but You look
Not
at the,
that's the
you look at the
international-
problems. 3 years have gone by.
Yes, madam.
Unless Mr. Sharma would have shown it to us, we would have proceeded. There is no opinion at all. Why will you certify a document to be true? It is your signature.
Yes, madam. That is there, madam. My
So if you don't see the original, why you should sign and certify it to be true? We'll consider and pass orders. We'll deliberate and at 2 o'clock. We will pass an order. We too will deliberate and then take a call. Now, this is very unfair.
There is no intentional understanding, madam. No intentional, madam.
No, we don't know. You see, that's why we called for your copy and then shown you that the page number 1 is 1 of 3 ends. The second page is 3 of 3.
Yes, madam.
Where is 2 of 3? If you don't see that much, then probably we'll be right in proceeding against you. We'll take a call, we'll think over.
Item 6 for motion.
May I please, your lordship, I filed affidavit, lordship, regarding undertaking, giving lordship, the event of I will not be defaulted furthermore. That was filed on that mark as ex lordship in the office.
Copy of the
Extra. आपने इसको डेली भी कभी मेरा डेली भी देखो ना ये बात देखिए बात कोई तो हो सकती है आगे में पता नहीं Assim, certo. Lordships, page 49. Lordships. That is at page 58. small for poor labor losses, daily labor that are specifically stated in losses. That can be covered, and if you are, your lordship direction give you unable to pay. Lordship short, small amount, maybe 2,000. Lordship poor person, that should be looked into. But able to, whether he is able to give, that is the problem, lordship. Lordship, small cost may be lordships.
They may be spending more on peanuts than the cost of litigation. 10 years we are condoning.
Lordships. That's my submission, specifically state Delaware, he moving here and there, initially Shivsagar, then.
No, you see, the petitioner knows about the opinion. He comes after 5 years and then files the review petition. After filing of the review petition, he vanishes for next 5 years. So it's not that he is not aware of the opinion.
That I admit in lordship, but because of
We are not reducing cost.
illiteracy and layman.
And we are making it clear that if there is a single default, this opinion will survive. It will be revived without adjudication. The single default of the petitioner will lead to revival of the opinion. But
5,000 lordship
No.
maximum.
no, we are condoning 10 years.
Lordship.
We are likely to increase it, not reduce it. Right, Mr. F.U. Barbuya, learned counsel for the petitioner. Also heard Mr. P.K. Medhi, learned CGC appearing for respondent number 1. Mr. G. Sharma, learned standing counsel for the FT matters representing respondent number 2, 5, and 6. And Mr. P. Sharma, learned additional senior government advocate appearing for respondent number 3. And Mr. H. Kuli on behalf of Mr. A. Ali for respondent number 4. Next person. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex-parte opinion dated 3/6/2016, passed by the learned member, Foreigners Tribunal, Bongaigaon number 2, Abhyapuri, in page 49, BNGN so and so, arising out of reference number so and so. By which the petitioner has been declared to be a foreigner who has entered into India after 25/3/1971 from Bangladesh. Full stop. Next para, it may be mentioned that as per the records of the learned tribunal, upon due service of notice on the petitioner pursuant to the initial order dated 13/11/2014, the notice was duly served on the petitioner, and thereafter he entered appearance before the learned tribunal on 12/2/2015, which was the date fixed for appearance on filing of written statement. Full stop. On a prayer for adjournment, seeking time to file written statement and documents, the matter was adjourned. And the next date was fixed on 18/5/2015 for written statement and documents. Full stop. Thereafter, the petitioner defaulted in appearance on 18/5/2015, 13/8/2015, 17/8/2015, 13/8/2000 in bracket present. Presence is recorded. Bracket close. For presence recorded, but written statement not filed. 3/10/2015, 2/11/2015, 18/12/2015, 1/2/2016, 5/3/2016, 8/4/2016, 11/5/2016, and 3/6/2016. Next paragraph. In this writ petition, it is projected in paragraph 10 that the petitioner appeared before the Foreigners Tribunal, Learned Foreigners Tribunal on 5/9/2016. And claims that due to Janmashtami, a holiday was declared. And it is also projected that thereafter the petitioner again went to the tribunal and found it closed and was under an impression that the tribunal is permanently closed down. Full stop. As indicated above, the opinion was already delivered on 3/6/2016. Full stop. Thereafter, no, not thereafter, full stop. After a deep slumber, the petitioner once again appeared before the learned member, Foreigners Tribunal, Bangaigaon number 2, on 25/1/2019, and filed a miscellaneous application under section 3 within bracket capital A of the Foreigners Tribunals within bracket Tribunals Order 1964, and prayed for setting aside the ex-parte opinion dated 3/6/2016. The learned tribunal, by order dated 7/11/2019, passed in Miss Case number 35 of 2019, arising out of case number BNGN so and so, page 58. Consider the provision of section, para, it will be para 3 within bracket A of the foreigners within bracket tribunals, bracket close order, 1964. That the ex-parte opinion will be entertained if it is filed within 30 days of the date of the said order, comma. Held that as per the decision of the full bench of this court in the case of State of Assam versus Muslim MOS LEM, Mandal and others, comma, with 2013 within bracket 2, bracket was GLJ 1 within bracket FB, refer to the observation of the of this court to the effect that the tribunal can entertain such application provided the proceedee could demonstrate the existence of special of the exceptional circumstances to entertain the same by of pleadings in the application filed for setting aside ex parte opinion. Accordingly, because the application was found to be time barred, the said miscase was dismissed. Next para. Once again, the okay, 3A as it stood before its amendment with effect from 30/5/2019. By which paragraph 3 within bracket A was renumbered as paragraph 3-C. Next paragraph. Once again, like the story in the fable, FABLE, of Rip Van Winkle, comma, the petitioner went into hibernation and concealed himself for a long time since 7/11/2019. And the present writ petition was filed on 15/2/2024 for setting aside the ex parte opinion and the rejection of the said order dated 7/11/2019 passed in miscase number 35 of 2019. Next paragraph. The next paragraph. The learned standing counsel for the FP matters has vehemently opposed the prayer made in the petition on the ground that the petitioner has not given any specific particulars as to where he was hiding after the rendition of the opinion dated 3/6/2016. It is also submitted that despite a lot of effort by the Superintendent of Police within the home, border Bongaigaon, the petitioner could not be apprehended pursuant to the ex-parte opinion. Accordingly, it is submitted that owing to the casual approach of the petitioner in approaching this court and intermittent defaults all throughout, the petitioner has been able to drag the proceedings which arose for 10 years as the reference was registered in the year 2015.
Reference 2008.
2008.
8 and notice 2014.
Notice on
Notice on lordships
2015.
2014.
14.
Lordship.
Reference of 3/6/2006. Reference of 2008, 2008. Whereupon notice was issued on the petitioner in the year 2000.
Notice dated 13/11/2014.
On 13/11/2014.
13 page 39 is the notice.
Next one. Taking note of the various events as narrated above, court does not find any merit in the challenge made to the ex-parte opinion dated 7/11/2019, as well as no, sorry, not 19. It is 3/6/2016, as well as the order passed in the miss case on 7/11/2019 by the learned tribunal. Next, nonetheless, as valuable citizenship right of the petitioner is at stake. Court is inclined to grant one opportunity to the opportunity to the petitioner to contest the proceedings of case number BNGN, so page 49. Full stop. Next paragraph. Accordingly, the said ex-parte opinion dated 3/6/2016 and passed by the learned member of Foreign Tribunal, Bongaigaon 2, Adhayapuri, in case number so and so, arising out of reference number so and so, as well as order dated 7/11/2019, passed in this case, passed by the same by the learned member, Foreign Tribunal so and so, in this case number so and so, page 58. On the conditions as enumerated below. Next paragraph. First, going to the ranking of the proceedings for 10 years, comma, as a precondition for setting aside this, the state ex parte opinion, as well as the order in this case, comma, impose a cost of rupees 10,000 on the petitioner to be paid, to be deposited with the member secretary, comma, Guwahati High Court Legal Aid Committee within a period of 2 weeks from the date of this order. Number 2, along with the copy of the acknowledgement of deposit of cost, comma, the petitioner shall appear before the Superintendent of Police within bracket border, bracket close Bongaigaon, within 4 working days thereafter, and furnish a bail bond of rupees 5,000 with one surety or like amount, with conditions of bail. Next paragraph. It is provided that in the event the petitioner does not deposit the cost awarded, comma, or does not appear before the Superintendent of Police in the bracket border, Bongaigaon, and take bail as directed, comma, this order shall stand recalled. Comma, which would result in the ex parte opinion dated 3/6/2016 to be revived, and shall be in full force. Next paragraph. In the event the petition takes bail within the time allowed and deposit the cost, comma, you would be permitted to appear before the learned member, Foreign Tribunal, Bangagaon number 2, Adhyapuri, within 7 days thereafter, and on the date of appearance, on the working day, 7 days thereafter, and on the date of appearance, comma, the petitioner shall file his written statement and also produce all the documents on which he intends to rely upon. Full stop. Next paragraph. Subject to compliance of the conditions as indicated above, comma, the said ex parte opinion dated 3/6/2016 passed by so and so in so and so, as well as the order dated so and so passed by so and so, page 58, are conditionally set aside by further providing that in the event of a single default of the petitioner in appearance before the learned tribunal, comma, the learned tribunal will be at liberty to close the evidence and pass an ex-parte opinion afresh. Next paragraph. At this stage, the learned counsel for the petitioner submitted that the petitioner is a laborer and is not in a capacity to pay the cost of rupees 10,000. Full stop. Next paragraph. In view of the inordinate default of 10 years in selling the opinion, the court is of the considered opinion that the cost of 10,000 awarded cannot be said to be in a higher side, and therefore the said prayer stands rejected. Inordinate and inexplicable delay.
One prayer, Lordship, instead of 2 weeks, that may be 3 weeks.
What, 3 weeks?
Lordship directed to deposit within 2 weeks. That may be 3 weeks, Lordship, because poor person may not be able.
No, you see that creates
Yes,
another
Lordship,
default.
10,000, Lordship,
Now,
yes.
now 3,000. If we delay it for 3 weeks, then your bail extends by another week. Then that means you are getting again from now you are getting 6 weeks time.
No. I'm not. Only one week.
You have a long.
Lordship's aware of the poor
You have a long planning.
single statement is there here and there he is working.
No, that's why we took an undertaking that he will appear.
Lordship undertakings, that's Lordship.
Achha,
3 weeks.
just there's a question on me that he will a single default. There is a single. There you add. This condition is imposed in view of undertaking filed by the petitioner in connection with this by way of an affidavit filed by the petitioner on 11/2024. That to the effect that in the event the writ petition is allowed, the petitioner will physically appear before the tribunal, before the learned tribunal in all the dates fixed without fail and even irrespective of his health condition. And he will further give undertaking that he shall not take any adjournment. Okay, make it 15 days. 2 weeks. We are only adding 1 day more.
Lordships. Obliged.
Item 7.
Yeah, please, Your Lordship. Your Lordship, kindly the matter may be passed over for the time being.
Item 8.
May please, Your Lordship. My lord, here in this case, earlier record was called for. Record
What
is
is your best document
my lord, documents, my lord,
except for voters list?
my lord. The booster list of 1953.
Was it exhibited?
It is, my lord, vernacular copy not exhibited. Then lastly may come to the
No, show
booster
the
list of
exhibited documents.
1966.
Hmm.
66, my lord. At page
66,
52.
page number?
Page 52, my lord, vernacular at page 53.
No, apart from this voters list.
Apart from voter list, my lord, the school certificate was produced and proved also. And my lord,
School certificate.
my lord, the voter list, by voter list, his linkage is established, my lord.
No,
My lord,
voters list, so many cases we find that they are all picked up. Then,
my lord,
then stories built up.
my lord. That maybe, my lord, scrutinized in the hearing, my lord, in detail, my lord. But for
No, but where is your school certificate?
school certificate,
Is it at page 80?
my lord, yes, page 74 is the school certificate. My lord, there is some name discrepancy, my lord. In school certificate, my name is Hekmat Ali Sarkar. My father's name written as Abdur Rahman.
That is the whole difficulty.
Abdur Rahman. And notice is also indicated that my father's name is Abdur Rahman. So these documents is proved by, and the school certificate, my lord, was proved by calling the headmaster did not come, the staff was sent for producing the documents. Therefore, the learned tribunal has discarded. The headmaster did not come, some subordinate staff has been sent.
No, but my esteemed brother has found out that the exhibit 3 and 4,
My lord.
they're only photocopies. So if you don't prove the original, there would be no reason for interference with the.
My lord,
opinion.
to original school certificate produce corona.
It is written in the opinion.
My lord.
You find in the opinion. My esteemed brother has found out.
My lord. Exhibit 3, proceedings submitted certified extra electoral roll of 1966 in respect of Goripur LSC Dhubri. Exhibit 3. My lord, Exhibit 3, my lord. My lord, that is voter list of 1966. It was certified
No,
copy.
page.
My lord, I am reading at page 136.
Page 137,
My lord.
fifth paragraph.
5, 6. Exhibit, my lord, 3 and 4. Photocopies of certified copies. No doubt certified copies are secondary evidence and are therefore admissible in evidence. But the absence of primary evidence, my lord, certified copies is proved, that is admitted.
No, photocopy or certified copy.
No, my lord, photocopies of certified copies.
Yes, that is the difficulty.
Lordship may kindly have a look at the, my lord, exhibits, my lord. Those are proved in original. How it cannot be considered, my lord.
No, it was not proved in original.
Record will say, my lord, what we have.
It is not proved in original.
Voter list of 1966 is the exhibit, my lord, 3, and exhibit 4 is the voter list of 1970.
ओरिजिनल तो देना रहेगा 53 certificate to be देना नहीं My lord, it is written cropped in original in 1766 voter list. My lord, in voter list of 1966, I find that there is no cropped in original.
Just a moment.
Fifty-three million. Oh no, it's 53 94. 74, 74. 74.
Heard. So A.R. Sigdal and counsel for the petitioner also heard. P.K. Medil and CC appearing for respondent number 1. Mrs. D. Sharma and its standing counsel for the FT matters representing respondent number 2, 4, and 6. And Mr. P. Sharma and an additional senior government advocate for respondent number 3. And Mr. H. Cooley on behalf of Mr. A. Ali for respondent number 5. Next. Pursuant to order dated 15/3/2024, the records of the tribunal is received. Most of the same is perused. It appears that the matter requires further examination. So accordingly, issue notice returnable forthwith without requiring the petitioner to take first steps. Full stop. By issuing rule returnable forthwith, the returnable petitioner to take steps. Next paragraph. But both sides on the prayer for bail made by the counsel for the petitioner. As the matter has been admitted for hearing, the court is inclined to provide that the petitioner shall appear before the petitioner, namely so and so, alias so and so, shall appear before the superintendent of police within particular order Which place?
My lord, judgment, my lord. Final
No.
order one.
No, bail before whom?
My lord, Lokhimpur.
Border, Lakhimpur, not Lakhimpur. Those conditions, default condition. This is a matter for hearing in usual course. 10 days to take bail.
My lord, deeply obliged.
Item 9.
Yes, which page is the opinion?
My lord, opinion is page 77 to, my lord, 80. 82, my lord. My lord, only due to name discrepancy, my lord.
Hmm?
The final order has been passed, my lord. My father
Correct.
name, my lord.
That's a good ground.
Circle officer, linkage document, annexure 10, page 49, my lord. My parents' name is in the voter list of 1966 and 71, my lord. And DW 2 deposed by my elder brother, my lord. Babu.
Your brother was never a voter with your father.
No, my lord. My parents' name is in the voter list.
With your brother?
And brother is also deposed by evidence as DW.
No. Is your brother and father together in the same voters list?
No, my lord.
Then is it possible for a family not to have father and son together?
My lord, sorry, my lord. My brother name in the voter list along with my father, my lord.
Where is that?
Page number, my lord, 26, annexure 3. Babul Ali.
Page?
Page 26, my lord.
Page 20?
26, my lord.
26.
My lord.
What is the name of your father?
Father name is Hamid Ali, my lord. No, my lord, 66.
Oh,
My
something is
father.
horribly wrong. Something is horribly wrong. Come to page 80.
Sorry, my lord. Sorry.
Come to page 80.
My lord.
In 80 says that to prove citizenship of the said Hamid Ali, OP unable to produce the other voters list so and so. Apparently clear that Hamid Ali was alive up to 89-90 and Hamid Ali is cast
No.
up to 89-90.
My lord.
So your father is dead.
No, my
In
lord.
2006, your father is dead.
My lord. To annexure 1, page 22, my parents is there, Hamid Ali.
Mr. Islam,
and-
please be prepared with the brief. We are more prepared than you are.
Annexure
We
2.
take it up next week. You be prepared.
Repeat.
Don't read the file here. I don't know how you gather the courage to be in the court without reading. We never had that kind of courage. You stand in the court without reading, and now you start reading. When I ask questions, you start reading. Then we ask you one question, and there you falter. You said your father is alive. As Mr. B. Islam and counsel for the petitioner is not prepared, matter is adjourned today, this after a week. Mr. Islam, we go from here at about 7, not before 7:30.
Right.
All my staff, ask them if I am not, when we are not there, ask them till what time they are here. Even after that, we get time to read.
Sorry.
Yes, Mr. Bara.
Item 10 with 11.
11. Dispose of by common order. Lordship would take up 11 first in the opinion. 11 is dealt with first. Is the wife and husband. Opinion starts from page 19. Operative part and analysis is at page 21.
You're referring to which brief?
11, Lordship. 11, Lordship. If their husband and wife, Lordship, their lineage will be different, Lordship. Different, but it is a common order. 11, Hamida Khatun. So, 10 or
Okay, Hamida Khatun.
Lordship, at page 19 it starts, Lordship. Analysis, Lordship, at page 21.
What is the best document you have for this Hamida Khatun? To connect, apart from voter list, to connect to your parents.
Actually, in all documents, Abdul Khalek is my father, and it is not disputed by the state, neither they have laid any evidence. However, during cross-examination, I had spelled one name of one of my paternal uncle, Lal Mia, Lal Mahmud as Lal Mia.
Lal Mia, yes.
For that reason only, I have been declared that he is a tutor. Lordship would see page 21.
Mr. Bora, you have been in this court for quite some time. You find that you'll find me as a tutored witness. When I say the name of the learned counsel, I make mistake and they correct it. That not this is my correct name. It happens every day. Every day I make mistake in calling the names, in recording the names of the learned counsel. Correct. And I've been knowing you for last so many years, and still I am making mistakes. So this is an example of a tutored witness.
But this happens very seldom. Lordship, anyway, may I read the operative?
Just a moment.
Paragraph. Lordship, written statement, it may be on the record, Lordship. I have not annexed. In Sahabuddin case, I have annexed it. Lordship, page 20.
Whether you introduce them in your written statement. Your uncle is not introduced here.
Page 20 in
what is
her
the-
cross
what is
examination
the-
only, he does it.
And what is this there in this item 10?
Worship, it's the husband who is in detention from November 2023. At page 20 is the 21 is the opinion. 23 logic in the critical analysis part. At one place, logic would see at 5 Roman 5, Exhibit 9 is a seal deed of the Sohor Banu, Nesa, and Jabed Ali, Muhammad Sahabuddin, late Usman, son of late Usman Ali, Abdul Hakim, son of late Usman Ali, all executed from these documents. It can be conclusively held that Muhammad Sahabuddin and Abdul Hakim are brothers, big sons of late Usman.
In your written statement, you don't introduce those facts.
But in the opinion, it is held like this.
Certainly.
Lordship, at
But
para
you
8,
see, that is also not proved. But what is proved as Exhibit 9 is a certified copy. So the original evidence was never produced.
what I wanted to show that it is already opined that we are sons of Usman. And another thing, Lordship, in the final opinion, it has been held that all are illegal migrants who have entered into the
Because
Indian
territory. There's no connect.
Sorry, Lordship.
There's a disconnect. There's no connection. Because to link yourself, you are linking on the basis of only the Gaungura certificate. All those contain state emblem. And the land document issue exhibit as Exhibit 9 is a certificate copy.
Lordship, my father Osman had 2 wives. I am the son of the second wife.
No. This land document you see, it's of 99, 91.
91.
Then How does it prove your lineage? It doesn't.
Lordship, my father's name appear in the voter list. Voter list, you know?
Only single voter list is very.
Yes, yes.
You are not even projecting your family. You are not showing any combined any voter list containing the name of the members of the family.
Lordship, at page 27, Lordship, kindly see. Sohar Banu's father, my mother's father, Jabed Ali.
That is something you are saying.
Lordship, at page 27, I have annexed a combined voter list. This,
No,
Lordship.
but you have not introduced this man in your written statement. So you are just anywhere you find voters lists, you just bring it and then say he is so and so, he is this, he is that.
Lordship, in the opinion,
You are
Lordship,
building up
kindly
facts.
see.
You are building up facts.
Lordship, kindly see at page 23. Sohar Banu's daughter of Jabed Ali, Lordship. Therefore, now when
No,
these
it is
documents may be.
it is not unique. It's not a unique name. These are all names which is borrowed by someone or the other. These names are ringing so familiar.
That is true.
If you don't give your family, it can't be located. Nobody can locate you.
Lordship, one opportunity if Lordship gives.
We are giving you bail for the time being, but it's only a temporary reprieve. We find no merit in your matter. But this item 10, but Mr. B.B. Bora, Learned Counsel for the petitioner, also heard Mr. P.K. Mehdi, Learned CEC appearing for respondent number 1, Mr. V. Sharma, Learned Standing Counsel for the active matters representing respondent number 2, 4, and 6, and Mr. Ms. S.T. Khan, Learned Counsel appearing on behalf of Ms. P. Barwa, Standing Counsel for respondent number 3, and Mr. P. Sharma, Learned Additional Senior Government Advocate appearing for respondent number 5. By filing this repetition under Article 2.6 of the Constitution of India, petitioner has assailed the opinion which page is the opinion?
Page 20, Lordship. 21.
Page 21 is the opinion. Opinion dated 18/5. 18/5/2018. And what is your explanation for the 3 years delay?
Lordship, yes, explanation. Lordship.
This is 2018, 2015, 7 years. How do you explain the delay?
Lordship, at page 14, para 14, page 10.
Taken into custody.
Lordship, Lordship, I asked, they also did not know. Yesterday also I asked, exact date.
Then it will lead to difficulty there to find out. Then we can't give you bail. We'll just say not to be deported.
Lordship will kindly consider my bail. Lordship, I will file an additional affidavit. if
No, do it
required.
because without facts, we can't give that bail. You are aware of it.
Yes, Lordship.
Just say,
Additional,
this will so. Next person to the order dated 28/6/2024. The records of the tribunal is received. Upon perusal of the same, it appears that the matter requires hearing. Accordingly, the court is inclined to issue notice returnable forthwith without requiring the petitioner to take steps. First one. List in the admission column. After
Lordship, after a week, Lordship, I will file an additional affidavit.
we're
Lordship
making
will
it 2
consider-
weeks. We're making it
2
2
weeks,
weeks so
2
that you can make it after 2 weeks.
Lordship, Lordship may consider my bail.
You file an application because these facts are not there. You find it very difficult to give you bail. So, in the meantime, if it is provided that the petitioner shall not be deported without the order of the court. Next para, the learned standing counsel for the FT matters shall communicate a copy of this order to the superintendent, transit camp, Matia Golpara. List after 2 weeks. Then item 11. Where Mr. BP Bora and the counsel for the petitioner. Also, it's same counsel for the respondents, so and so. By filing this repression under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 18/5/2018. This is same opinion, huh? Page 19 here. So and so by so and so, by which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Next para. Pursuant to order dated 28/6/2024, records of the tribunal is received. First off, there is the same. It appears that the matter requires some some matter requires a hearing. Further examination. First, accordingly, issue notice returnable in 2 weeks without requiring the petitioner to take fresh steps. Next page. In the meantime, it is provided that the petitioner, namely Muhammad Hamida Khatun, shall appear before the Superintendent of Police within bracket border, Birkul Morigaon, within 10 days from the date of the order and furnish bail with those conditions. Next, the default condition. Next, list after 2 weeks. 10 days time to take bail in item 11.
So in the item 10, Lordship, I will file another mentioning the date of registration.
Do it.
Personally, deeply obliged.
Take a short break and come back.
ইয়াত প্যারাগ্রাফ ফিল আপ করা নাই হাইকোর্টের কপি পড়ছে না নাইবা আর ভারতী দাস 12
Item 12.
Yes.
What kind of mercy petition, Your Lordship? I received notice, my lord, but out of bona fide belief, instead of approaching the learned tribunal, I approached the Gaubura concerned, my lord. Lordship, and he assured me that my name would come up, Your Lordship, in the NRC. As it didn't turn up, Your Lordship, the police is searching for me, Your Lordship, approached my household. So, Lordship, I have.
But there's an opinion of 2023.
Lordship. Lordship, on the similar ground, this honorable court coordinate bench has disposed of a matter. That actually, excuse me, Diog na kote. Na diso na duta copy. Copy duta matter din.
প্যারাগ্রাফ ফিল আপ করছিলে নাকি এই যেটা
So everybody in your village,
Lordship,
Garo Ghutu,
my
go
lord,
to, they all go to Gaura.
probably my lord. Race 4 matters are similar ground, my lord.
Yes, Mr. Sharma, she's
Probably.
candidly admitted that
No,
instead of merit, she's invoking the mercy jurisdiction.
lordship. Some cost may be imposed lordship. Yes. This is not a case that petitioner does not know about the proceeding lordship. He appeared then lordship. IPR করে নাই নাকি IPR করে নাই
One opportunity be given to me, madam.
28. Mr. Sharma, there's a registration certificate at page 28.
Yeah.
You should give an opportunity to the petitioner.
Yes, Lord.
Okay. But we are also inclined to award a cost of rupees 1,000 to be paid to the Secretary DLSA of the district, Baksa.
Fine.
Heard. This D. Bhuya, Lanet, Senior Counsel. Assisted by Ms. B. Bhuya, Lanet,
B. Bora.
B. Bora, Learned Counsel for the petitioner. Also heard Mr. P.K. Mehdi, Learned CEC appearing for respondent number 1. Mr. G. Sharma, Learned Standing Counsel for the FT matters, representing respondent number 2, 3, and 2, 3, 5, and 6. And Mr. H. Kuli appearing on behalf of AILE, Learned Standing Counsel for respondent number 4. And Mr. P. Sharma, an additional senior government advocate, appearing for respondent number 7. Next para. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the ex-parte opinion dated 9/1/2023, passed by the learned member, Foreigners Tribunal, Baksa and Tamilpur, page 17. In so and so arising out of IMDT case number so and so.
Next to.
By which the petitioner was declared to be a foreigner, has illegally entered into Assam after 25/3/1971. Next para.
Next. Article.
The in the next para, in the said ex-parte opinion, the learned tribunal has recorded that after due service of notice, the after due service of notice on the petitioner on 11/10/2021, the petitioner remained absent on 11/2/2022, 23/5/2022, 28/2022, and 11/11/2022. And therefore, as the petitioner did not contest the proceeding by filing written statement or evidence, said ex-parte opinion was passed. Next part. In this writ petition, it is projected that the petitioner had approached the Gambra of the village, who had assured that her name would appear in the NRC She did not contest the proceedings. First of, they said ground is expressly not acceptable. As a good and sufficient ground for not appearing and contesting the proceedings despite receipt of notice. Next paragraph, the learned senior counsel for the petitioner has submitted that the petitioner has sufficient materials to establish that she is a bona fide citizen of India, and she prays for giving one opportunity to the petitioner to contest the reference. Next paragraph. Under the circumstances, we do not find any fault in the impugned opinion dated 9/1/2023, passed by the learned member, Foreigners Tribunal so and so in so and so, as the petitioner was consciously absent in the proceedings despite receipt of notice. Next paragraph, be that as it may, as the issue of citizenship is a cherished right, required to be established by the petitioner, we are of the considered opinion that one opportunity be granted for ends of justice to the petitioner to present her written statement and to contest the proceedings. Next paragraph. The impugned opinion dated 9/1/2023, passed in so and so, is conditionally set aside on the following terms. Next paragraph. Number one, the petitioner shall appear before these superintendent of police, the bracket border, bracket closed, Baksa, within 10 days from the date of the order, and shall furnish a bail bond of rupees 5,000 with one surety of like amount, the satisfaction of the said authority. Those conditions, it is make clear that as the said impugned opinion is conditionally set aside, on failure of the petitioner to take bail, this order would stand recalled, and the ex-parte opinion dated 9/1/2023 would stand restored. Next para. In addition, we provide that the petitioner shall deposit cost of rupees 1,000 to the member secretary, District Legal Services Authority, Baksa, and produce a copy of acknowledgement before the, along with a certified copy of this order before the learned member, IMDT, Foreigners Tribunal, Baksa, and Council, and on such appearance and on compliance of conditions, the said learned tribunal shall appear before the so within within 25 days from the date of this order, and file a written statement along with all necessary documents and on compliance with the conditions as rendered above, the learned member, Foreigners Tribunal, Bucks and Tamil shall. Give an opportunity to the petitioner to prove a case and decide the matter afresh in accordance with law. Next paragraph. On conditions indicated above, this petition stands conditionally allowed to the extent as indicated above. Which would and then this order. Under the conditions of this order, if not complied with, all the consequences as indicated above shall follow. This is item 12.
Minor.
Item 13,
13
Same.
is on similar ground.
same,
Minor. Order of, impugn order 7 to 2023.
7 to 23.
Lordship.
Item 13 is a male, Narayan Tara Das. She's a lady or
Lady minor.
lady, Nayan Tara Das. Srimati
Minor.
Nayan Tara Das. Additional. Opinion dated
7 to 2023 from page
7 to
17
22
onwards.
7 to 2023. Page number
Lordship page 17.
17. Okay.
Operative portion starts from page 18. Judgment starts for order starts from page 18.
Same ground.
Lordship.
17, same.
In the additional affidavit, we have stated that ground, taken that ground, although it was missed out.
The next item is also yours.
Lordship. It's a 7 to 2023. All Gaurav Khator, your Lordship.
7 to 23.
My lord.
He's a male.
Male, my lord. Page 16
Mahendra
onwards.
Das. And opinion is page
Page 16 onwards.
same order.
Okay, sir.
He and she will change.
Lordship, one more, next one also. 9/1, 2023.
Which one?
Item 15.
15.
Nine one, page 15 onwards.
She's a lady.
Lady, my lord.
Srimati
Srimati Kamona Das.
Kamana, Kamana, Kamana Das. Opinion dated
9/1/2023.
9/1/23, page 15. Same ground.
Lordship.
Case number and he and she will change. Okay.
Lordship, we have it for 5 more days time. 10 instead of 10 days, can it be 15 days, my lord?
15. Now you have
Yeah.
started bargaining. Okay, 15 days.
Obliged.
15 and for appearance before the tribunal 25 days.
Mine.
That is the difficulty in wholesale and retail trade.
My lord.
Yes, item 17.
My lord.
Yes.
Yeah, please, your lordship, with respectfully, my lord, I beg to submit that here is one order sheet in the one or two order was left out, my lord. In the original order sheet, it was not annexed.
Okay.
In the certified copy also, my lord. But my case is relevant after filing of the WS and before WS.
But what is the ground of delay? There's an inordinate delay.
There is a delay.
My lord.
This is opinion.
Opinion at page, my lord, 73.
73.
73, my lord.
73.
Relevant paragraph will be 4, my lord.
73, you see this
70,
is an opinion of 22.
my
You have
lord.
come in 24.
My lord.
About 2 years delay. What is the explanation?
After impugned order was passed by the learned tribunal, the engaged counsel of the learned court below, he taken the file and he assured that he will file a writ petition before the Honorable High Court. But till 2024 August, the case was not filed. When the petitioner comes to know that no case was filed, therefore they was taken back the file, my lord. And the complaint and the at page, my lord, 76, the advocate himself given the note that he has released the file on 11/8/2024, my lord, to her husband.
No, you see, have you filed any complaint before the
Complaint, my lord, at page 78,
78?
my lord, the husband of the proceeding filed this complaint, my lord. The proceeding on her
Does
level.
does not inspire any confidence. Doesn't have the money receipt.
Money receipt is here, my lord.
You have it.
Yes, my lord.
What was that?
Excuse me.
Hmm.
Out of 90 dates, 5 dates, the learned tribunal itself adds on, my lord, due to paucity of the time, and 7 dates, the advocate itself was absent, my lord. Before pass the order, if some order was reflect here, the engaged counsel, learned tribunal also specifically mentioned to the engaged counsel also to be present on next date. But next date was not present. Thereafter, date was fixed for ex-parte. On that date was not present, my lord. And
No,
this,
that is okay about the council, but
my lord.
what did you do for appearance? You also never appeared.
My lord,
Blaming council is very easy
my lord.
because he's on record. But you did not say anywhere that you were present, but the council was absent.
My lord, some dates was not communicated by the engaged counsel to the present proceeding, my lord, because several dates engaged counsel himself was absent. And this proceeding was initiated within the COVID period also, my lord.
Okay. We are allowing it. You deposit a cost of rupees 1,000 before the Party High Court Legal Aid Committee.
My
Lordship, earlier occasion, Lordship perhaps call for the records.
It's there.
Yes.
Default is there.
Yes.
Default is there. Is correctly stated.
earlier date also I mentioned, my lord.
Heard. I'm you, Ahmad, and counsel for the petitioner. Also heard Mr. P.K. Medina, that's CEC appearing for respondent number 1, Mr. G. Sharma, and standing counsel for 50 matters for respondent number 2, 3, and 6. And Mr. H. Kuli Learned Counsel on behalf of Mr. A.I. Ali for respondent number 4 and Mr. P. Sharma, an additional senior government advocate appearing for respondent number 5. Filing this petition under Article 226 of the Constitution of India. Petitioner has assailed the ex-parte opinion
3/12/2020.
page 74, dated 3/12/2022, passed by so-and-so in so-and-so. Thereby declaring the petitioner, namely, declaring the petitioner to be a partner of post 25/3/1971 stream. Next paragraph. The learned counsel for the petitioner has submitted that although the proceedings before the learned tribunal was adjourned on 19 occasions, but on 5 occasions,
Five occasions, my lord.
5 occasions, the tribunal could not take up the matter due to paucity of time. And on
And 7 dates, advocate itself was
and
absent, my lord.
on 7 dates, the learned counsel engaged by the petitioner was absent. So it is submitted that as dates were not communicated to the petitioner, and she had defaulted in appearance, which led to an ex-parte opinion by the learned tribunal. Though she has filed a written statement.
14.
Next one is also submitted that as the final opinion was not, as the final opinion rendered on 3/12/2020 was 22 was not communicated to the petitioner. The petitioner has also filed a complaint against her engaged counsel before the Bar Council of Assam, Nagaland, etc. on 12/8/2024. Accordingly, it is submitted that there is some delay in a delay about 2 years in selling the said opinion. Next paragraph, the learned standing counsel for the FT matters has opposed the claim made in this writ petition on the ground that the default part of the petitioner can be noted from the contents of the impugned opinion. Moreover, it is submitted that despite a lot of effort taken by the Superintendent of Police, within bracket Borpeta, the border Borpeta, petitioner could not be apprehended. Next paragraph. On a projection made by the learned counsel for the petitioner that the petitioner has sufficient documents to prove her citizenship. What is of the constraint opinion that one opportunity may be granted to the petitioner to contest the proceedings. Next paragraph. Accordingly, without finding any fault with the opinion rendered by the learned member for Foreigners Tribunal 11th, Sorbo. Said opinion is conditionally set aside as follows. Same conditions as earlier. Set aside ex-parte opinion. You say will deposit a cost of ₹1,000. The member secretary, District Legal Services Authority, Borpeta.
My lord.
And produce a acknowledgement thereof before the Learned member, Foreigners Tribunal, 11th Survey. Those conditions that if it does not appear, it will be set aside. We called the other past today will be stand recalled. Those conditions.
Deeply obliged,
Conditionally allowed with cost.
my lord, obliged.
You appear before the tribunal within how many days?
10 days, my lord. 10 days,
Okay, making it 15. 15 days from the date of the order.
obliged,
Appearance, date of appearance. Okay.
deeply obliged.
Item 18.
May I appear, Lordship?
Yes, Mr. Sarkar.
What is the case, Lordship? The order is a, opinion is a from page 21, Lordship. And the opinion is a page 23, Lordship.
But there is no document to connect you with your projected parents.
Parents, very soon.
You approved only the school living certificate.
Yes,
Was
Lordship.
the headmaster examined?
No, Lordship. He was not examined.
Mr. Chaudhary, there would be no merit in the matter. In your written statement, you don't even say the name of your father.
It is there, Lordship. Wahab Ali.
In your written statement,
Yes, Lordship. Page 16, Lordship.
page
Page 16, Lordship.
15.
16, Lordship.
And what is the explanation for 3 years delay, 4 years, 3 years delay in approaching?
Lordship. Not directly, Lordship, but these villagers tend to listen to their fellow villagers, Lordship. That's the problem, Lordship.
Pardon me?
Lordship, the villagers, Lordship, they tend to listen to fellow villagers, whatever they say. That's the problem, Lordship.
But here you should explain some delay. There's no explanation at all. We'll consider your bill on receipt of records. In the meantime, we will not be deported.
Lordship.
Heard. Mr. U.P. Saliha, Net Counsel for the Petitioner. Also heard. Mr. G. Sharma, Net Standing Counsel for the FT Matters, representing respondent number 1, 2, 4, and 7. And Mr. P. Sharma, an additional senior government advocate, appearing for respondent number 3. And Mr. P.K. Medir, an CVC, appearing for respondent number 5. And Mr. H. Kudi, and counsel appearing on behalf of AILE for respondent number 6. Following this repetition in the Article 226 of the Constitution of India, question as a same, the opinion dated 30th January 2021. It's page 21, passed by so and so in so and so. They were declaring the petitioner to be a foreigner of post 25/3/1971 stream. Issue notice returnable in 4 weeks. Give a date after 4 weeks. Yeah. Give it in January. Returnable on so and so. Requisite extra copies of the declaration be served on the journal. CGC, State and Departmental Council within 2 days. 2 working days. Next one. Let the relevant records be requisitioned from the learned tribunal. Next paragraph. The prayer for bail shall be considered on receipt of the records of the tribunal. Next paragraph. In the meantime, in the event the petitioner is apprehended, he shall not be deported without the order of the court. Next paragraph. List on so and so. They're giving a fixed date.
One will be represented by Sharma Sarvat, Chief Secretary. Respondent number 1, Chief Secretary.
Respondent 1 is by Mr. Sharma. Okay. Respondent number 1 by Mr. Sharma. Then Mr. G. Sharma would be for
2, 4, 7.
4 and 7.
Yes.
Okay. Continue after lunch.
Yes.
Is the Advocate General present? You're there?
In this second half, I'm told that Leonard AG has to attend some. He has some engagement in the second house. So I have informed the other side that in that case they may make their submissions. So I'll
No,
prefer
that would
taking
be
up on
difficult.
Monday.
That would be difficult because my esteemed brother would not be there in the bench next week. So therefore, question of parted will be very difficult. And this habeas corpus matter, we cannot spill it for long.
On Monday. He'll make his submission on Monday.
When Bajaj is on 18. It's the 10th December. 10th December. Third and fourth.
Mrs. Ghosh,
Yes, Lord.
you see, in that event, we
Yes,
suppose that the matter would be taken up on 3rd and 4th of December. If it is spilled over on 3rd for some reason, we take it up on 4th. Is it convenient for you?
Yes, Lord.
You're taking consent of?
Yeah, I'll just verify one. Because I was just talking to my senior.
Huh.
Because we have discussed about Monday, I'll tell that it will be 3rd, that is Tuesday and Wednesday.
Monday it may not be.
Yes, Lord. I'll just confirm, just 2 minutes.
Yes. Monday is a bit inconvenient.
Yes, Lord.
So
Yes, Lord.
the 2 dates would be either you take it
Third or
either 3rd or 4th,
Lord.
or 4th or 5th, whatever is convenient. We tell it to the court master, will pass orders.
Yes, Lord.
It will not be taken up on board. We'll adjourn it on your prayer and then we fix it on
3rd of
either 3rd, 4th or 4th, 5th, whatever is convenient.
Yes, Lord.
Item 18, 8-1. 8-1.
May I please, your lord? My lord petitioner, before your lordship is a female, my lord. My lord, in this case, my lord, the petitioner did not have any document to prove her linkage with her father or grandfather, my lord. But she, on behalf of her my lord, his one paternal uncle and paternal aunt deposed before the learned tribunal, my lord. My lord, first, my lord, your lordship, page 21, my lord, 20 and 21, voter list of 1966, my lord.
But what's your explanation for coming after 5 years?
My lord, that explanation, my lord, your lordship will find, my lord, page 15, para 27, my lord.
That's a good ground. You're into custody now.
No, my lord.
It's not a good ground. You see, you otherwise protect a very large family. Come
Yes.
to page 23, come to page 25. You otherwise project a large family.
Yes, my lord.
Then
5 paternal uncle, my lord, including his,
Then-
including her father, and my lord,
still you are poor.
my lord. My lord, the deposition of DW 2 and 3, my lord, I found, my lord, very consistent, my lord. There is no discrepancy, my lord, what I have found, my lord. Otherwise, she did not have any document, my lord, to prove her linkage with her father because she was married prior to enrollment of her name in the voter list at her paternal address, my lord. And
No, there is another reason. You're not stated that you don't own any property. You don't. Where is your written statement?
my lord, written statement. Page 36, my lord.
Yes, 36. Yes.
36.
You see, there's you come to this from your written statement. First, you are in this first few voters list. You are in under Papara. Then again, your projected mother's address changes to village Achiapara.
My lord, in this respect, my lord, I have stated in the writ petition as well as in a written statement, it was also stated, my lord. Your lordship page. This is adjacent village, my lord. Sometimes it is called Aisorapara. Your lordship will find in the voter list itself, my lord. A polling station, my lord. Hondokarpara LPS.
Where is that?
My lord. My lord, page 30, my lord.
30.
Page 30. Voter list of
Along with the names, even the village has a alias.
My lord, page 30, my lord.
30.
30, my lord.
Yes.
Your lordship will find village Aisorapara. Name of polling station. 1352 number Paschim Hondokarpara LP school, my lord. In the previous voter list, my lord, kindly page 28, my lord. Same polling station.
Okay, we are giving you protection. But Mr. EHMR Chaudhary and Counsel for the petitioner also have the PK Vedina, that's CC appearing for the respondent number 1. Mr. G. Sharma, Lanet Standing Counsel for the FT matters representing respondent number 2, 4, and 6. And Mr. P. Sharma, Lanet, sorry, Mr. Atal Lanet, Government Advocate appearing for respondent number 3, and Mr. H. Cooley on behalf of Mr. A.I. Ali for respondent number 5. Filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 30/7/2019, passed by the London member for this tribunal 10th Bopeta in FT case number so and so. Where is the opinion? Page number?
My lord, page my lord, 56 million.
Filed by so and so in so and so, thereby declaring the petitioner to be a foreigner of post 25/3/1971 stream. Opposing the admission of this writ petition, the London Standing Counsel for the FT matters has submitted that the writ petition is not maintainable due to delay in latches part of the petition to assail the opinion dated 30/7/2019. As this writ petition was filed on 13/11/2024. Next, keeping the issue of delay in latches and maintainability to this writ petition open, issue notice returnable in 4 weeks. Mr. Requisite extra copies of the writ petition will be served on the CGC State and Departmental Council within 2 working days. Let the relevant records be requisitioned from the consent tribunal. The petitioner shall appear before the Superintendent of Police within bracket border, be Bopeta. Within 10 days from the date of the order, pay for and apply for bail. Furnish a bail bond and one surety of like amount to be satisfied and set authority. All those conditions and default clause. List after 4 weeks on the set of trial court tribunal's records. 10 days time to take bail.
Deeply obliged.
Item 20.
May I please, Your Worship? No, sir, earlier the petitioner was declared as a foreigner of 1966-71 stream. And subsequently, my lord, is 72, the impugn order he has been declared, she has been declared as post 71.
Who were your witnesses? Where is the opinion and your written statement?
My lord, written statement is page 51, man.
51. And the opinion?
Opinion on page 72, Lordship.
Where is your father's first voter list?
Lordship. 1970, that is page 30, my lord.
30.
30, my lord. Atwar Rahman. Petitioner started. Yes, 51.
You don't find anything wrong in the opinion. You try to make out a story and then something very,
Lordship, the address of
very, in a very shallow,
my lord, may
shoddy
call,
manner, and
my lord
story
may
doesn't
call
match.
for the records of both the cases, my lord.
Story doesn't match. You're building up a story from the dates available in the voters list. Age and dates mentioned in the voters list, you are now trying to make up a story. In the Kabinama goes, therefore there is no document to connect you.
My father deposed, my lord. Father, in both the cases, father deposed, my lord, and the voter list.
Father was there.
likeness,
What is, father is DW?
DW2, my lord.
DW2. Which page?
His lordship, cross-examination, page 63.
Page number
63.
This makes the story more worse.
My father, in the 17 voter list, his name is there. In the village possessor. And my lord, that was exhibited. And it was also exhibited in the earlier opinion by of the different tribunal, my lord, page 82. The 1970
You're
voter
building
list.
up your case only on the basis of the voter list from here and there.
There is also land document, but that was not exhibited, my lord. There is a Khotian, my lord, final Khotian.
page 82 also not exhibited. Okay.
M. Ali.
List out of 4 weeks on the city of records. Bail within 10 days.
All right.
For motion, time being item 7.
Please, your lordship.
Yes.
In this case, LCR was called for earlier on 13/3/2024, lordship.
Yes.
There was no interim in this case, and LCR in the meantime has received. This is a contested case, lordship. Page 86 is the result by the tribunal. I don't know what to do. Page 86, lordship.
44, I think.
Lordship.
Who are the witnesses in your case? How many witnesses are there?
Lordship, I have summoned OP as DW1 and lordship DW2, his father, DW3 from the school certificate to prove that certificate, lordship. Junior assistant, office assistant, lordship. And OP exhibited 13 documents A to O, lordship.
Kabinnama was not exhibited.
Lordship.
Kabinnama was not exhibited through your.
No, lordship, voter list of his father, annexure 4, page, lordship, and 1989 voter list, page 25. 25, 26. His father name is there, lordship. Serial number 873. And serial number 870, grandmother, lordship. Serial number 874, his mother. This is 1989 and 1966, 70, lordship. His grandfather and grandmother's name are there. 1966 voter list, page 21 and 22. Monse. Page 22, Ahmad Ali Bepari, grandfather, lordship. This is 1966, lordship.
Mr. Sharma, Home Department officers are not interested to be here.
Lordship, I have intimated lordship. Again, I will communicate lordship.
Then there's hardly any reason for us to take all the trouble. Section 9 of the burden is not on us. You see, if the Home Department does not appoint government pleader in these cases,
Yes.
there's no point in making an inquiry and taking so much of effort to look into the documents. The government appropriate authority in the government does not think it is proper. Why should we spend so much of time and energy? This is R.A. Chaudhary, counsel for the petitioner.
Archer.
with the CEC for respondent number 1, Mr. G. Sharma. Technical for 3 matters for respondent number 2, 4, 6. R. Tarudaya, government advocate for respondent number 3. And Mr. H. Kuli on behalf of Mr. A. Ali for respondent number 5. Opinion is 83. 30 January 2024. Filed by so and so and so and so. Same order notice called for the records, bail. Petitioners will appear before the Superintendent of Police, Border Dhuri, within 10 days and take bail. 10 days time to take bail.
15 days, Lordship. 15 days are,
Right?
will take some time to obtain the certified copy, Lordship. LCR already received, Lordship.
For this bench?
No, Lordship, in normal.
No,
procedure.
not normally. 10 days.
Lordship,
Ask them to be here.
obliged.
You will also need some security people. Let them travel with you, give you some security for some time. You look into this record, you will understand what you are trying to convey.
Yes, Lordship.
Mr.
Item
Sinha,
3.
we have deliberated and we are of the opinion that we do not proceed against you, but we'll have to deposit a cost of 5,000 and do the rectification. You file an additional affidavit. Not taking stern steps against you. But you have to deposit a cost of 5,000. I mean, heard. Mr. BP Sinha, learned counsel for the petitioner. Also, heard Mr. E.K. Mehdi, learned CCC correspondent 1. Mr. H. Kuli on behalf of Mr. A. Ali for respondent number 2. Mr. G. Sharma, learned standing counsel for the FT matters representing respondent number 3, 4, and 6. And Mr. R. Tarudaya, learned government advocate appearing for respondent number 5. Right. I think this is a petition. So and so. Opinion dated 29. Which page, Mr. Sinha? Mr. Sinha? 53.
Lordship 83.
Hmm.
Oh, sorry, Lordship, sorry.
53 is up. 53. 29/12/2020. Passed in so and so, by so and so. By which the petitioner was declared to be a foreigner. Post 25/3/1971. Next paragraph. At the outset, the learned standing counsel for the FT matters has produced a copy of the opinion dated 29, a scanned copy of the opinion dated 29/12/2020, which is impugned in this writ petition. And the maintainability of this writ petition has been questioned on account of the fact that page 2 of 3 of the said opinion, whereby the discussion of the tribunal is made on in the matter, has been withheld by the petitioner as the copy of the opinion annexed to this writ petition as Annexure P is incomplete without annexing page 2 of 3 of the said opinion. Next paragraph. The in reply, the learned counsel for the petitioner has submitted that is annexed the impugn opinion as received by him. Next paragraph. In this regard, the court is of the considered opinion that in this regard, the court has put a query to the learned counsel for the petitioner to produce the certified copy of Annexure P, which it was to which it is submitted that it does not have a certified copy of the said opinion. Full stop. We take a serious note of the lapse on part of the petitioner in not annexing the petitioner and his learned counsel for not annexing page 2 of 3 of the impugn opinion. Full stop. The copy of Annexure P, annexed to this writ petition clearly discloses that the first page of the opinion is page 1 of 3, and the last page is page 3 of 3. Full stop. Therefore, before filing, they said error of not supplying page, not annexing page 2 of 3 is a serious lapse on part of the learned counsel or the petitioner who has certified the said copy to be a true copy. Full stop. Therefore, he has certified the document to be true without having in his custody the original certified copy. Full stop. Next, at this stage, the learned counsel for the petitioner pays for some time to file an additional affidavit to bring on record the full the certified copy of the opinion dated 29/12/2020. For the sale, in this regard, the matters answers spread the matters adjourned today. So, however, though we take a serious view of the lapse on part of the learned counsel for the petitioner, we take a lenient view of the matter. Nonetheless, they inclined to impose a cost of rupees 5,000 on the learned counsel for the petitioner to be deposited with the Guwahati High Court Bar Association for its benevolent fund. A copy of the copy of the acknowledgement of such payment shall be produced on the next date of listing. Next paragraph. We grant liberty. How much time you need?
4 is to
Huh?
4 weeks.
Prayer made by learned counsel for the petitioner. 4 weeks time is granted to the petitioner to bring on record the certified copy of the impugn opinion. List after 4 weeks.
Upgraded item 43. WP Criminal 18/24.
We have forgotten the context, which is the order which has been, which is challenged in this writ petition.
Me lordship, the order, me lordship at page, it is page 26-27, by which me lordship the 10,000 granted towards interim maintenance, me lord. That has been assailed, me lord, before this honorable court, me lord. Can you see me lordship while passing this
Just
order?
a moment.
Yes.
Just, just, just a moment. Just a second. And we take note of it. Next paragraph, we also take note of the of the decision of the Supreme Court of India, para 62 of the decision of the Supreme Court of India in the case of Shalini, Shalini, Shyam, Shym, next word Shetty, Shetty versus Rajendra Shankar, Shankar, next word is Patil, comma, within bracket 2010, bracket close, 0 Supreme, within bracket SC, bracket close, 609. Which reads as follows. Para 62 quote. Just 62, then 72. '74, '80, TO2, 83. Next paragraph. Next paragraph. Next paragraph. In the present case, in the cost title at page 1 of the writ petition, this application is under Article 226 of the Constitution of India. So, however, in statement made in paragraph 1 of the writ petition, the present application is stated to be preferred under Article 227 of the Constitution of India. So therefore, going by the cost title, the present writ petition has been registered as WP writ petition within bracket criminal CRL number 18 of 2024 and laid before the division bench of this court. Full stop. Next, we also take note of the fact that in an earlier round of challenge to the impugn order dated 28/7/2023, passed by the learned principal judge, family court number 2, Kamrup Metro, Guwahati, in FC within bracket criminals, bracket close, case number 162 of 2023, filed by the petitioner, criminal revision petition number 399 of 2023 was registered, which was assailed before the Supreme Court of India as referred herein before. Next, be that as it may, at this stage, the learned counsel for the petitioner seeks liberty to withdraw this petition and to approach this court in terms of the liberty granted by the Supreme Court of India. Rest of the prayer is allowed. The matter stands dismissed on withdrawal. Liberty is paid for. We grant you liberty.
Obliged.
Whether it is that suppose you have paid for litigation expense and interim maintenance, which has been statutorily provided for in section 125. So litigation expense has not been granted to you.
Yes, my lord.
So whether it will be an interlocutory order or some kind of order.
It is an intermediary order, my lordship.
Find out, explore, then granted liberty already, so you explore the right.
In fact, I have taken before the honorable single judge, my lordship, in the previous litigation, 1904, also Family Courts Act, my lordship, says, but.
Explore. We are just asking you to explore.
Yes, I am obliged. I am obliged.
Upgrade item 37 for admission.
May I please, Lord? Against the ex-parte order. Page number 16 is the ex-parte order. In terms of the said order, my lord, the petitioner is taken into custody, his detention camp. My lord.
बहुत दिन आए थे
What do you think of this service report? What is your first impression?
সম্মানপূর্বক বিনীত নিবেদন এই যে আমি
No, we have read that. But what is the first impression? What is the first visual impression you have of this document?
Your Lordship, a notice was served, Lordship.
Now you please tell us why a witness will sign in the top and the writing is below.
Yes.
Normally, Jarikarak will write something and then witness will sign.
Yes, Lordship.
So what is the impression? After the witnesses sign, you can write anything. Is it not? It's quite unnatural that somebody would sign a service report prior to the Jarikarak report.
Yes, Lordship. Lordship.
Yes, what is your explanation in your petition? What statement you have made about the service report?
Notice was not served, and in the
Where you have said?
paragraph
was
number
that?
3, my lord. My address is wrongly written in the notice.
Is wrongly mentioned. What is your address?
My address is Koragari, village Koragari. And in the reference, it is shown Noliao. Therefore, I refuse to accept that notice, madam. And requested the process server to correct my address, but he submitted this report, madam.
Then he has a valid ground. He has also mentioned that
Yes, Lord.
he has a valid ground. If you give him a notice of different address, he has refused it. And he is admitting it that he has refused.
Yes, Lordship. Lordship,
We set aside this.
let him go and contest the case, Lordship.
Heard. Mr. H.A. Ahmed, learned counsel for the petitioner, as well as so also heard Mr. E.K. Mehdi, and CEC for the Union of India, respondent number 1, Mr. G. Sharma, and standing counsel for FT matters representing respondent number 2, 4, and 6, Mr. H. Kuli, on behalf of Mr. H. Kuli, then counsel on behalf of Mr. A.R.D., standing counsel for respondent number 3, and Mr. R. Talukdar, learned government advocate, appearing for respondent number 5. By filing this repetition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 6/4/2024, page 16, passed by so and so and so and so. Ex-parte opinion dated so and so, passed by so and so. By which the petitioner was declared to be an illegal migrant. Next paragraph. The said opinion is assailed on the ground that the petitioner is a resident of village Karagari, Karagari, NC, block number 9, but in the notice issued by the learned tribunal, no, we'll have to dismiss your petition.
If he is not,
Look at this record again. Mhm. You see, look at the initial notice. This man was served notice at village number 9, block Naligaon. His fingerprints and all, everything is recorded at Naligaon. Therefore, the only conclusion is that he has changed his place of residence after police inquiry. His photograph is also taken. Therefore, you can't say that he's not the man. Therefore, either you make a correct statement or we have to dismiss the writ petition.
Well, I am not saying this is not,
No. That will not happen.
and I am, my voter list since 1983, I am in Koragari.
That we
I have
don't know.
managed the voter list.
You have seen the document for yourself.
Lordship.
Now, if you are a resident of a different village, will the police be able to get your photograph, fingerprints from a different village? Everything is recorded. Because if on that ground we interfere with the opinion, then tomorrow you'll go and say that I'm not the person concerned. We can't permit you to do that. You have been identified, and then look at the number of effort. Not less than 10 times police has gone to your place. You're not found. Your village elders and all, they have said that you have refused. Then you can't be permitted. Either you bring an affidavit to say correct state of facts, or we have to dismiss the writ petition. It was correctly served.
I am the person.
You're taking advantage merely of your shifting.
I am that person. That is no doubt, my lord.
You bring it on record, because now your assessment contradictory.
Para 3 is completely contradictory to records. Record speaks otherwise.
But my voter list since 1983, my lord.
No, that we don't
You have
know.
been requested by the investigating officer, please furnish us. This is the first time I have seen.
He gives you a notice.
Gives notice and please furnish these documents. He asked for about 10 number of documents.
Lordship.
And 9 block Naligaon. You signed.
Your thumb impression is there.
And
this
plus,
Yes, lordship.
everywhere you're full
10 for
10
Naligaon,
fingerprints,
10 fingerprints. How
All
can
at
you
Naligaon.
say now, Karagari? You might have shifted, but you are the person, same person.
Same person, yes.
No, bring it on record.
Only option
Admitted.
could have been that appearing before the tribunal, you could have said that I have now shifted from Maligaon to Karagari. Otherwise, I don't
Last
think.
opportunity.
That you bring on record. You make a statement in the writ petition. You either you file an affidavit or we dismiss the writ petition. We have got two options. Not we, you have two options.
Lordship.
We pass an order in your writ petition. As on date, we have only one option, but you have two. Which
On a
one do you
timely
choose? Affidavit, okay. You just say, both sides are represented, the learned counsel for the petitioner, praise for is granted. How much time?
1 week.
1 week's time to file an affidavit to bring on record the statement regarding his address. In view of the fact that the records from the tribunal discloses that the IO had visited the address on which notice was served, and his and the petitioner's photograph and fingerprints were taken. And a notice was also served on the petitioner for producing records. Full stop. Although the non-counsel for the petitioner has submitted that he is the same person, but let the said fact be brought on record by way of an additional affidavit, for which liberty is granted to the petitioner. Full stop. Matter stands adjourned today, list after a week, as prayed for.
Publish. Hello.
There you also had, and his statement was also recorded by the IO.
Upgraded item 38 for admission.
Yeah, please, your lordship, the person is in detention. We are pressing the IA.
Just a moment. Mr. Sharma, please again note it down. We had asked you to tell us by virtue of which judicial order is the division bench which is taking up the matter.
Yes, Lord.
We want that.
Maybe select on the video, not on the petition. Not on the petition, the issue for an petition.
Kindly come to. May I, your lordship? Kindly come to page 42. It's the LBO report. The name is given Kadir Pramanik.
Mr. Sharma, you have gone through the records? There's no
No.
reference at all of him being a foreigner.
Yes.
It is this, LVO says thereafter the Superintendent of Police, the annexure B of the ERO is considered as a ground. Annexure B says nothing.
Lordship. Page,
Look at this record.
yes. But I.
Annexure B,
Yes, Lordship, I have seen Lordship.
it says nothing.
Lordship,
This, before the annexure B, look at this page. Ah, yes.
this is reference Lordship.
Yes, here it says annexure B is accepted as a ground for reference, right?
Annexure B is prepared on the basis of LVO's report, Lordship. Annexure A.
That is also interesting. The man comes and says that his name is Paramanik and language recorded is SMS. There's nothing, there's no reference at all.
Lordship, this case is based on the LVO's report, Lordship.
After LVO, it goes to the election officer.
Yes, Lordship.
But
When Lordship in the year of 1997, when Lordship intensive revision of electoral roll was.
so we understand the background,
Yes, Lordship.
but you see, the reference must have some basis. There are judicial pronouncements.
Lordship, can it be on Monday, Lordship?
Monday.
I shall try my best.
Monday.
Allow me to go on bail. I'm in
Apprise your
detention.
Lordship. Monday, nothing will happen, Lordship.
I'm in detention.
He's under detention, every day counts. Okay, Monday.
Allow me to go, yeah, request for bail and then fix it for Monday. I don't have any.
We have taken note of what he is trying to say. We are giving him 1 day. Doesn't matter. Mr. Dear DK Agarwal, counsel for the learned counsel for the petitioner is present. All the, you say both sides are represented. Mr. G. Sharma, standing for the active matters. Took some time to go through the records of the travel and address the court. List on Monday, 2/12/2024. Most of the learned counsel for the petitioner is granted liberty to renew his prayer for bail when the matter is next listed.
Much of.
We have to rise for the single bench. Yes, you're there, Mr.
Lordship.
No, not you.
Admission for 23 item, Lordship. It is case of 2017, Lordships. And
We'll take
last
it up.
time
We'll
filed
take it up.
affidavit also, Lordships.
We'll take it up, but
Yeah, time may be fixed.
we'll do it.
One date may be.
We'll do it. We'll rise for the single bench of my esteemed brother.